The third element in the four elements of a valid legally enforceable contract is capacity. You must have the capacity to enter into a contract. And the issue of capacity comes up in three different ways. First is age. Are you old enough to be in a contract? Because if you're a child or a minor, we say you're not old enough to understand the consequences of entering into a contract. And with only a couple of exceptions, generally a child is not bound to a contract promise. The second of the three elements of capacity, the three ways the capacity issue comes up is intoxication. If you're too intoxicated to understand the consequences of what you're entering into, then you're let off the hook on the issue of capacity. But be careful on that one, because as you will see when we talk about one specific case, I'm not sure you can always count upon the intoxication capacity defense to a contract. And the third way that capacity comes up in legal contract disputes is actual mental impairment. Are you actually too mentally impaired to understand the consequences of the contract you're entering into? So let's look at these three capacity issues in a bit more detail. If you're a minor, you're under the age of 18, then the general rule of law is that you cannot be held to a contract. You just get off the hook. But there are some exceptions to that. One is if you look like you're 18 and you lie about your age, you misrepresent your age to the person you're entering into the contract with, and it's reasonable for him to believe you, then you may be bound to the contract even though you're under the age of 18. Another one is if you ratify the contract after you turn 18. So you agree, a classic scenario that occurs is you agree to buy a used car from somebody and they want $5,000 for the car, and you say, well, I can only give you $1,000 down and I'll give you $300 a month until it's paid off. So you give them the $1,000 down, and you take the car home and you wreck it the second day you have it, so you decide you're not going to make the rest of the payments. Well, if you're still under 18, you may be able to get out of that contract because you're underage. But if you made 6 or 7 payments and during the payment period time you had turned 18, and you make one payment after you turn 18 and then you wreck the car and you say, well, I'm not going to make the rest of the payments because when I entered into the contract I was underage. Now you're on the hook for the entire amount of the contract obligation, because after you turned 18 you made a payment on the debt. You acted as if you approved of and ratified the contract once you were an adult, and so now you're treated as an adult. You're bound to the contract. Another thing that you have to be careful of when you're relying upon getting out of a contract because you're a minor is in some states what they have is they have a law that says when you get out of a contract you entered into as a minor, you rescind the contract, and if you can't do a rescission of the contract, then you don't get out of the contract. Now, a rescission requires that when you're undoing the contract, you restore the parties to the original position that they were in before they entered into the contract. So in the car sale we're talking about, the old fellow that sold the young person the car would have to give him back the $1,000 down payment, and maybe if he made a first monthly payment he'd have to give him back that payment too. But the young person would have to give back to the guy the $5,000 car in the same condition it was in when he bought it. And so if the car was totaled and he can't give back the car, then the young person, even though the contract is rescinded because of age, young person still owes that guy $5,000 for a car of equal value. So in a rescission state, a young person doesn't get off just scot-free. California is not a rescission state with regard to minor children, but be careful about that. There is one other exception to the rule with regard to minority, and that is an emancipated minor. So here's what happens with regard to emancipated minors. You're 15 years old and you're having a tough life. Your parents are drug addicts and they beat you, and so you run away from home, you drop out of school, but you get a decent job and you fall in love with a girl, and she gets pregnant. You've been living in the back of your car up until then, but now you've got to have a place to live. And you have a halfway decent job, and so you're making enough money that you could afford to pay the rent on an apartment. So you go to a landlord and you ask him to rent an apartment for you and your wife-to-be and your little baby. And the landlord says, I'm sorry, but even though you have a good job, I cannot rent you an apartment unless you have a parent or someone to co-sign on the lease with you, because you're a minor and you can't be bound to a legally enforceable contract, so I can't lease you an apartment. So you're in a terrible spot because your parents are not going to help you. So we have an exception to the rule for that. And the exception to the rule is if you are an emancipated minor, you're supporting yourself, you don't get any support from your parents, then you can enter into legally enforceable contracts for things that are classified as the necessities of life. So a shelter, a place to live, a rental of an apartment, yes. Food, clothing, medical care, yes. Luxury items, maybe not. But you can enter into valid, legally enforceable contracts for the necessities of life if you are an emancipated minor. And then there's one last legal question that comes up with regard to minors and contracts. Suppose a 15-year-old kid signs on to a contract for the purchase of a car that he wrecks, or for some other item, and he defaults on the payments. The question comes up, are the parents liable for contracts that are entered into by the minor child? Do the parents have to pay? And the answer is no. The parents are not liable for contract liabilities that are entered into by the minor child, unless, of course, the parents co-sign or personally guarantee the contract. So remember, in the area of capacity, there are three things. There's minor age, are you old enough? And then there's intoxication, are you sober enough? And the third one is, are you mentally impaired? So looking at intoxication for a moment, the interesting thing there is it's kind of a no-brainer that if you had been drugged or somebody put a Mickey in your drink and you were so intoxicated involuntarily that you didn't understand the consequences of the contract you're entering into, you would not be liable for that contract. But interestingly enough, the law says even if you're voluntarily intoxicated, if you're the guy doing the headstand on the kegger at the frat party and you're intentionally getting bombed out of your mind and you sign on to a contract, you may be able to get out of that contract with the defense of intoxication later. But there is one aberrant case, and because of that one aberrant case, if I were you, I would not count on being able to get out of a contract just because you're intoxicated at the time you sign it. So I would not go to a party, get bombed out of my mind, and some friend is there pressuring me to sign some contract and say, oh, to get him off my back, I'll sign that tonight, and if I want out of it in the morning, I'll just tell him I was drunk and have intoxication defense. I would not count on that because of this one aberration case. There were some farmers, and on Friday nights they would go down to the small town nearby, and there was one bar restaurant that was a favorite for the farmers, and they'd take their wives there for dinner, and they'd do a lot of drinking. And one night two of the farmers were down there drinking with their wives, and the one said, you know, I think you got the best piece of farmland in the whole county. I've always been kind of jealous of that rich farmland you got down there. And the other farmer said, oh man, I've had so many problems this year with the machinery breaking down and the pests eating the crop and, you know, the expenses. I'd sell you the whole dang place for $5,000. And the other guy laughs and says, sold. He says, let's write up a contract. So they're drunk, and so they get a cocktail napkin and they start writing down all the details, every single detail of what you would write down ordinarily in the sale of a farm. They wrote down the acreage, the time for delivery, the time for payment, They wrote down what livestock would be included in the sale and what livestock would not, what equipment would be included in the sale and what would not. And then they dated it and they signed it, both farmers. And because it was a community property state, they even had their wives sign it. And then they laughed and they went home. Well, the next morning, the one farmer wakes up with a bad hangover because somebody's pounding on his door. And he goes to the door and it's the other guy who's standing there with a cashier's check for $5,000 saying, "When can you move out?" And he says, "That was all a big joke. We were drunk. You know, it's not a real contract. I'm not going to sell you my farm, my whole farm, for $5,000. Well, they went to court over it. Big lawsuit. And the one farmer gets there and says, "I'm not going to sell this guy my farm for $5,000. I was drunk. I didn't understand what I was doing at the time." And the judge says, "Well, let's take a look at the paper that you guys wrote up and signed. By the way, you wrote this down on the napkin, right?" And he says, "Well, yeah." And he says, "Well, you wrote down every single detail of what would be required in a contract for the sale of a farm. You wrote down the price, the payment time, the time of delivery of the farm, the acreage of the farm, the animals that would go with the sale, the pieces of equipment that would go with the sale. You wrote down every single detail of what it would take to complete a contract for the sale of a farm. And yet now you're telling me that at the time you wrote this, you were too drunk to understand the consequences of what you were doing?" And he says, "Yeah, I didn't understand." And the judge says, "I'm sorry, in this writing, I see no evidence that you did not understand all the consequences of what you were doing. So you owe this guy a farm." So because of that case, if I was you, I would never sign something just because I was drunk, thinking I can get out of it later. Okay, so that's all we have on intoxication. The third way that mental capacity issue comes up with regard to contracts is if you are actually mentally impaired. And if you are mentally impaired, then if you sign a contract, it is either automatically void or it is voidable by taking it to court. And whether it's automatically void or just voidable depends upon whether or not there's ever been a prior court hearing where some court made a determination already that you're not competent to manage your own affairs and they appointed a guardian or a conservator for you. If there's already been a court determination that you're not competent to manage your own affairs, then any contract you enter into is just automatically void and unenforceable. But if you are kind of borderline impairment and most of the time you manage your own affairs, but this time someone snookers you into a bad contract and you want out, you can take that to court and it's not automatically void, it's voidable by the court if the court makes a finding that you're too impaired. And by the way, those cases can be absolutely heartbreaking. And if you have people, loved ones in your family or friends that are facing problems from being either born mentally impaired or facing old age and dementia problems, you want to watch over them like a hawk if you can. You don't want to make them feel that their independence is threatened, so you got to walk a fine line. But in this age of drug addiction, I've seen many, many cases where a drug addict will insert himself one way or another into the life of a person who's mentally impaired and then just rob them blind. So be on the watch for anybody having anything to do with drugs to get involved with any loved one that you have that's mentally impaired. So that's it on the third element of a valid legally enforceable contract, which is capacity to contract. Comes up in three ways: age, are you old enough? Intoxication, are you sober enough to understand what you're doing? And mental impairment, are you actually mentally impaired?